Hello, everyone. I am Desiree Kennedy. I'm a professor of law at Toro Law Center, and you're listening to the Toro Law Review podcast. Today, I am so excited to welcome to the podcast Daniel Kiel. Daniel Kiel is the FedEx Professor of Law at the University of Memphis, where he teaches constitutional law and education and civil rights, among other courses. He is an outstanding researcher and scholar, and he has long worked on issues of education, citizenship, equality, and race. He wrote and directed the documentary, The Memphis 13, which focuses on the first students to desegregate public schools in Memphis. He was awarded a Fulbright Fellowship to research educational disparities in South Africa and has been published in law journals, the USA Today, and the Washington Post. And most recently, Kiel authored the well-researched, well-written, and compelling book, The Transition, Interpreting Justice from Thurgood Marshall to Clarence Thomas from Stanford University Press, published in 2023. Professor Kiel, welcome and thank you for joining us. It's a pleasure to have you on the podcast.
Yes, thank you so much. It's a pleasure to be here.
So why don't we jump right in, right? Your book is intriguing in so many ways, and one of the unique and fascinating aspects of the book is that it combines the study of two very different jurists who seem to be polar opposites on nearly every aspect of their lives and ideas in one study. For our listeners, can you first share a little bit about your thesis? And then I want to talk about more of the themes of the book.
Sure. So, as you said, I think that the book tries to bring together two people that history has connected in a particular way, but whose views on a lot of the important American questions are very different from one another. So Thurgood Marshall and Clarence Thomas are connected in that Clarence Thomas is the justice who replaced Thurgood Marshall in 1991. That's the transition that is the transition that the title refers to. And the idea for the book, so that, I don't know if this is necessarily the thesis, but it's definitely the germ of the idea, comes from a dissent that Justice Marshall wrote on his final day as a justice, or a final day before announcing his retirement. And in that opinion, which is a case called Payne versus Tennessee, it actually comes from here in the same county as Memphis is in. I'm going to mess up the quote. I don't have it right in front of me, but he says something essentially. He's complaining about a change that the justices have made on it's a case about victim impact evidence and the death penalty. And he's upset that he's dissenting, and he's upset that they have reversed essentially a decision from just a few years earlier. And he says, neither the law nor the facts have changed in the past 4 years. Only the personnel of this court has. And I think it's so poignant that the personnel of the court would change further, with his own retirement. So he must have had that on his mind. And so it got me thinking about the impact of these transitions. And then this particular transition, I think, is of, both underrated and maybe misunderstood importance. And so that's really what the book is trying to do, is to sort of put it in context of its moment, but also use these two stories, which are both really extraordinary American stories, no matter how one feels about the sort of ideology of either justice. I think the two biographies are both really compelling, and their work is obviously very different from one another, but they're connected in this way from this transition.
Yeah, I mean, that's a great description that you started us off with. And there's so many little nuggets in there that I want to get to. But before we get to the nuggets, right, I want to figure out, how did you get started here? Was it from the Payne case? And I know in the book, you talk about a very personal connection you have with that case, the dissent that you just mentioned. how did you get involved? How did you get started? And was it that case?
Not really. I do have this connection to the Payne case, which is, kind of it just all comes together. The Payne case was a case in 1991, and at that point, I was not practicing law. I was not old enough to be practicing law at that particular time. But the firm that represented Purvis Payne in that case was the firm that I would eventually go work at when I left law school and moved back to Memphis. And the case was still ongoing. Purvis Payne was and is still in prison. And there had been a new law that allowed for DNA testing of some materials. And so I ended up being the lawyer that at that same firm who ended up arguing a sort of new round of the Purvis Payne case. Obviously the decision had come down in 1991 on victim impact evidence, but um, this other DNA issue was something that ended up on my desk years later. And so I had read the case just in preparation for that, but I was not a professor at that point in time. I was just doing, I was a lawyer. And so I was aware of it, and I stayed aware of the Purvis Payne case, which could be its own podcast episode. It's an interesting case that's actually still ongoing. Um, but it was really honestly from class that I got the germ of the idea to actually bring these two justices together in a studied way. And one thing I should say at the outset, the book, I have a perspective on which justices' views I more readily align with, right? And I'll just say up front, Thurgood Marshall is a hero of mine and as a person, and his work is honestly like what led me to want to go to law school. And even after having sort of studied his work, for many, many years, I still feel that way about Thurgood Marshall. I don't think I'm unique in that way. And so I also tend to be somewhat skeptical of some of the positions and perspectives of Justice Thomas. But the book is trying to make the case that for both of them, and I try to treat the work, though I've just confessed that if I had to pick, I would side with Justice Marshall. The book really works to take the work of Justice Thomas for what it is. And so I asked my students to do that as well in an education course I teach every year and I have taught. And so what would happen sometimes would we would pair these opinions, from different eras of school desegregation, and obviously the way that school desegregation or school equity cases are argued in 1954 is different than in certainly this past summer, but the wording changes, and so but yet we're reading these cases on back-to-back days and not 20 years apart or 30 years apart. And so my students really responded to the juxtaposition of, for example, a dissent from Justice Marshall in the 70s and a concurrence from Justice Thomas in the 90s, both kind of confronting the same issue, which is continued racial injustice in the schooling system, but approaching it with different solutions, but both of those solutions being rooted in a desire to bridge that gap, bridge those racial gaps. And so I think Justice Thomas is often thought of as someone who's not interested in furthering or reducing educational injustice or racial injustice. And I think that criticism is fair. But Justice Thomas says and thinks that he is furthering that effort. And so, and some of the things that he is saying are not inconsistent with what other leaders and Black thinkers over the years confronting this problem of injustice have said or thought before. It's just no one has been in a position of power in the way that Justice Thomas is, and so it makes it a little bit different.
Yeah, and I appreciate your confession, right? The reality of where your heart lies, but the book reads as a fair assessment of I think both jurists. So I think you managed to be very clear-eyed and objective in your analysis of the jurists. And you're also very careful in your historical and biographical research of how each justice may have come to their perspectives, in part based on their own lived experiences. So I think it's interesting the way you combine history, biography, and legal analysis in this one piece. And you talk about the book being about the relationship between law, government, and citizenship. Why was it important for you to take this approach that is not always the approach that we take as lawyers? Why was it important to take this approach to this work?
I think that we as lawyers maybe pretend that the people who make decisions, whether they be, I think when we're talking about a president that's making a decision, or even members of Congress that are making decisions, we're very comfortable saying, oh, they're just being driven by politics, or they're driven by their own personal experiences, and that's open in those two branches of government. And in the judiciary, we like to pretend that they're um, able to leave out all of that of who they are. And so I think when we do that, maybe we elevate the judiciary, which, could be a valuable enterprise, but we do that at the while also losing the humanity of the people that are involved in these decisions, which often help explain why they're reaching particular conclusions. And so part of it is that. Um, Part of it is I love telling stories, and I don't think that you can understand how these lives without, or these opinions without understanding the people behind them. Injustice in both of their cases, and the book, as this discussion already sort of reveals, the book is not intended to be just about um, Black justices talking about problems and racial issues. However, it focuses in that space, particularly in schools, because that is where these two particular justices write most passionately. And it's also a space where the sort of really significant American questions, not just legal questions, but American questions about belonging and inclusion and democracy are, really, really intense, right, in the race space. And speaking of citizenship, the relationship of government to citizen is is an incredibly complex story when we're talking about African Americans. And prior to Justice Ketanji Brown Jackson, these were the only two that could bring lived experience on those questions into what they were writing, and they often seemed to, from my perspective, when they were writing about schooling, and so that kind of was the approach, and then the legal analysis, because the way in which this job is, right, as a Supreme Court justice, the way in which you get to express yourself is through legal analysis or through legal opinions. And so that was the medium through which these two historical figures operated. And the book and some of the cases that are studied in the book is it's about, let's say, the relationship between the federal government and the state government, or it's about the role of the judiciary in crafting remedies. But it's really those are the legal analysis, which is huge. But those are bigger. Those are sub questions of bigger American questions that I think we should all be asking them.
Well, I think, you spend a lot of time on the education cases. They're not the only cases that you talk about in the book, but they're a perfect place in which to engage in this discussion, in part because I think both justices are so passionate
Yeah.
about these issues about equity and education, but also because education is a place where the political and the personal, right, really come together in a way that reveals a lot about what we think about full American citizenship. And
Mhm.
speaking of education and passion, one of the anecdotes in the book that I would love to hear more about is the anecdote that you tell about Justice Thomas's interaction with the high school student from
Yeah.
Washington, D.C., Cedric Jennings. And I'm going to let you tell the story, unless you want me to give you the sort
Yeah.
of the background on that. But I'd really be interested in why you included the anecdote of Thomas's interaction with Jennings, and the detail with which you describe his advice to Jennings, which really reveals, I think, a fair amount about Justice Thomas. But I'd like to hear from you why the anecdote's included.
Sure. So I think in part, I'm pushing against a narrative about Justice Thomas that he doesn't care about the futures of younger Black Americans. I think that that's a narrative that's out there about him. Even from the time of his confirmation hearings, there were comments about lifting the ladder up behind him at now that he has reached the sort of pinnacle of the legal profession, and so he's often critiqued in this way, and I think that um, a lot of people feel betrayed by that, you know, and it expresses itself in that narrative. Um, and yet there seems to be, and I don't know Justice Thomas, and I wasn't able to, I reached out, but I wasn't able to connect with him for this book. So everything I have is, reporting rather than actually observing or knowing anything firsthand. But I am aware that this is not an infrequent thing that Justice Thomas does, which is if he sees a young Black scholar student that is recognized, achieving, he'll make a point to connect with them and bring them to his chambers and have, sort of, play some sort of mentoring role to the extent that the person would welcome that. And so it just so happened that one of these people that he reached out to was a young man named Cedric Jennings, who ended up having a book written about his journey from DC into Brown University. And the book's called A Hope in the Unseen. And just as a side note, my wife did college counseling, and she was the one that sort of gave me this book at some point, and I read it, and she didn't know that part was in there, and I was reading through it, and I was like, oh my gosh, this is really interesting to know about Justice Thomas. And so that's why I thought to include it, and just to sort of give a little further detail. So Cedric Jennings goes, and my suspicion is that this conversation is not uncommon among the young people that Justice Thomas interacts with in this way, and he asks him what he wants to study, and Justice Thomas then goes on and on about how Cedric, when he goes off, first of all, he's kind of scoffs about the idea of going to Brown, and he really insists that Cedric not study African American studies or really any of the sort of soft sciences, history and government and those kinds of political science areas. Um, he thinks it's a sign of a sort of weak academic background, and when he hits his clerks, he's always looking for the science, the hard sciences, um, and then he also leaves Cedric with this advice, and I can't remember it, with absolute precision here, but this advice that you have to essentially remember who you are and not be trying to please others, because essentially others are never going to, you're never going to be enough for them. And it's a really tough message to deliver to a young person. But I think it's also really revealing about where Clarence Thomas is, where Clarence Thomas is as a person, a person that seems just deeply wounded, um, and and untrusting of those whom critique him, and who just see the world in a different way than he does. That being said, another thing that I hear, again, I can't say from firsthand, is that he's a person who knows everyone's name in the Supreme Court. I saw Justice Sotomayor speak, and she was asked something about him, and she said he's the most generous person among her colleagues, which is something that a lot of people don't see either.
Right.
Of course, you've got to balance those stories with genuine critiques of his work on the court. Of course, so too with Justice Marshall. Justice Marshall holds on to the sort of push for integration in a way that's probably out of step with others, that are pushing for educational justice during the latter part of his career.
Yeah, the language that you say that Thomas uses in counseling the students is fairly strong, right? He
Yeah.
tells them to avoid classes on race relations. Don't say that you're a Black person, say that you're just a person. And again, as you said, warning him away from studying that history and that experience in school. So this is the same justice, right, that you write about in terms of his perspective on the affirmative action cases. You go into depth about Grutter and his opinion in that case. So I would love to hear about the extent to which or how you think Justice Thomas's very strong opinions on race and African American studies as a legitimate source of study impacts his decision on these cases, right? We just got another Supreme Court case on affirmative action in education very recently. Can you tell us a little bit about your perspective on how his views on this being a legitimate source of study impacts his decision in the affirmative action cases?
Sure. So, I mean, even in that portion that, the specific conversation with Cedric Jennings, you can see him pushing against the idea of labeling. And this is the idea that you're a person and not a Black person. And this is something that's consistent in Thomas's work from the EEOC and into his positions as a judge and then justice. He is someone who is very, very resentful of group association. And so the idea of African American studies, is anathema to him, because he doesn't feel akin to the Black community. I discussed this speech that he gave to the National Bar Association sort of national convention. And it's essentially like a plea that I don't have to believe what you believe in order to be a Black person. I have a right to my own opinion, and it's a very complex relationship. What I think is really interesting about the affirmative action cases through his career is that Justice Thomas aligns with the more conservative justices in being skeptical of any sort of use of race for, you know, in the most recent case in sort of college admissions, but it's also in other sorts of areas as well. Um, and but what makes him really different than any other justice, and I think that he is the only justice who could say could have this perspective, um, is that whereas other conservative justices might oppose affirmative action, you know, based on their own personal ideologies and backgrounds, you know, so I think I would include biography in that as well, um, but also on grounds of what the 14th Amendment means and the language in the 14th Amendment and color blindness and all of these sort of legal theories as to why affirmative action is a violation of equal protection. Um, but Justice Thomas, he's on board with all that. He concurs with all of that. But what he adds into the conversation every time this comes up is that it's not just that it is all of those things, the sort of traditional legal analysis, it's also bad for African American students. And so, you know, he always is using the phrase like the so-called beneficiaries. You know, the idea of so-called beneficiaries suggests that it's his view of these programs, these policies, is that they're illegitimate, that they don't benefit anybody, um, which of course is such a strange thing for someone to say, um, given his own life experience, right? But his own life experience, and it goes back to this idea of individualism for him. Um, he believes that individualism explains his story, and of course it does. He's a very hardworking, well, high achieving student throughout his life, and but yet there's this resistance to the idea that assistance could be actually beneficial. There's so many instances in his career where, you know, he's denigrating these programs as though the world is equal and the preference is making it unequal. Whereas, you know, my perspective on that is the exact opposite. The world is unequal, and the preference is trying to bridge that gap.
Yeah, and you state that he goes even a little bit further than that, right? You talk about how he talks about how students are, and I think this is in the opinion, right? Unprepared students are being tantalized with University of Michigan degrees, and you talk about how his argument evinced a profound lack of faith
Yeah.
that other Black students could accomplish what he had. So it sounds as though your thesis is not only, right, does he hold these views, but that he also thinks that it is unlikely that others will be able to meet the challenge that these institutions create for them, which is interesting. And it makes me wonder, and I want to pivot a little bit because one of the things I really loved about your book is that although it talks about Marshall's and Thomas's origins and goes through their biographies, it's also very current, right? You talk a lot about the current political issues and anti-government tensions that were raised during the pandemic and then after the last election, and that we, are again seeing in this election cycle. And you trace a line from Thomas's perspective on and sort of this anti-government stance with Donald Trump, right? And you said it made him sort of a patron saint of
Mm-hmm.
21st century conservatism, particularly the brand tapped into by Trump. So I would be very interested in having you talk a little bit more about how you think his anti-government stance and conservatism, right, is impacting the current legal issues. We just had a Supreme Court decision on um, Trump and the
Mm-hmm.
Colorado ballot. So we have an expert here. I'd love to hear your thoughts
Sure.
on how these election cases that are yet to be decided might play out, given how much you know about this particular justice and his position, his senior position on the court?
Sure. So, I mean, great question, because it's there's so much wrapped up into um, this particular moment and the court in this particular moment, and um, in a lot of ways, the court has become highly predictable, in that at no point in, at least as I know it, American history has the alignment ideologically and the alignment of the appointing president's party been exact, one-to-one match like it is in this particular time. With regard to this anti-government, and it really does connect actually back. You're pivoting away from affirmative action, but it's the same basic principle. Um, there's a long history of sort of libertarian, conservative, um, leave me alone, that's a thread in American history, of skepticism of government, keep the government out of my business. The Bill of Rights, some of those provisions are rooted in that exact um, principle. And again, just like with the affirmative action situation, Thomas is okay. He's on board with all of that, but his reason for being anti-government is rooted in the history of government's relationship to African Americans. And there's a long history of anti-government activism within the Black community, as there ought to be, right? In a government that embraced, legalized enslavement and segregation and exclusion from civic life and citizenship and voting and all, if that's the government, then why wouldn't you be anti-government? Which is, of course, a great irony with Marshall, whose entire career was suing the government, and yet as a justice, he is very favorable towards government policies to remedy those things. His perspective is the precise opposite. Government caused those problems, and therefore there's a government responsibility to address them. Whereas Thomas, government caused those problems, and therefore government is, poison essentially, and is illegitimate. And so the sort of modern Trump type conservatism, is that in a lot of ways. That's one of the threads that sort of feeds into Trumpism. The thumb in the eye, the drain the swamp, the norm sort of bashing, anti-government positions. But I would have to say it's a lot more complicated than that, in that Justice Thomas's position towards the police, or towards criminal prosecutions, or towards executive power is not always anti-government, and it's sometimes selectively anti-government, and selectively anti-government in a way that lines up with partisan politics. And so sometimes when I talk about Justice Thomas, I would love to stop studying Justice Thomas in 2007, when he wrote a concurrence in the parents involved case in Seattle, which is essentially the end of Brown versus Board of Education. Somehow Brown versus Board of Education was cited to strike down a local school, or two local school districts' plans for more diverse schools. And so
And
Brown versus Board of Education.
I
Yeah,
was just going to interject that it was a plan developed by the school district itself, if I recall correctly.
right. Yeah,
It
a
was not
voluntary
court
plan.
imposed, right? It was not
Exactly.
court imposed. Yeah, I was just
Exactly.
clarifying that for
Yeah, a
listeners.
voluntary plan for diversity
Mhm.
was unconstitutional. Why? Because of Brown versus Board of Education somehow. And so Justice Thomas writes a concurrence in that case, and it's very interesting. Um, but the reason I say I wish I could stop studying him at that point is because I think from that point on, at that point he's about 16 years into his tenure on the court, and he starts to become less compelling as a jurist. You know, he's starting to repeat the same thing, you know, as all judges do, you know, once they've been on the court a certain amount of time. This is Marshall as well. He's predictable and repeating. But it also starts to become more difficult to disentangle Thomas from the Republican Party. And I think that some of the reporting that has come out in the last year and a half or so really feeds into that narrative as well. That this is a person who may have roots in, you know, quite honestly, like really important and compelling Black liberation thought. You know, he is part of that ideology. If you know, some of the things that he has written are, you know, similar to Malcolm X or Marcus Garvey or others. And that may have been a part of the story to get him to this point, but it doesn't seem to be really driving any of his behavior as a justice, you know, in the last 10 to 15 years. And instead, that drive seems to be coming, you know, more in a partisan manner. And yeah, the Trump connection is significant. You know, a lot of Justice Thomas's clerks served in the Trump administration. And of course, now he is the senior justice. And so whenever Chief Justice Roberts is not in the majority, it's Justice Thomas who has assigning privileges. That was really never something that Justice Marshall got to experience.
Well, I have to ask, right? I would love to hear, given everything you've studied about Thomas and Marshall and everything you know about the Supreme Court and constitutional law, your views on court reform, right?
Yeah.
Where does all of this research and thought put you on where we might go and what might happen with regard to reforming the Supreme Court? Is it needed? And which of the many proposals that are being tossed around do you think are credible?
So I think it is needed. And I will give a little bit of background to this. So the book is called The Transition. And in an earlier iteration of this book, there were several chapters that were attempting to actually quantify which transitions were the most impactful. And so I would use data and I would use comparison of one justice to another. And really, I was keeping kind of my time frame from like the appointment of Chief Justice Warren in 1953, basically up to the present, and trying to identify, because I'm calling that the sort of modern Supreme Court, and trying to identify which transitions had the most impact. Because I knew that not every transition is the same. And, you know, just to take an example, the appointment by President Biden of Ketanji Brown Jackson as the first Black female justice is of huge symbolic significance. And I think that she's done an incredible job thus far. But it's not transformative for the working of the court in the sense that she replaced Justice Breyer. And though she has different approach and different perspectives and different skill set than Justice Breyer, so she's not the same person, but in terms of like likely impact on outcomes, there's just not that much difference between the two of them. Yet I knew for the Marshall Thomas transition, or in terms of more recent ones, the Ruth Bader Ginsburg to Amy Coney Barrett transition, that's going to make a huge difference on outcomes and reasoning. You know, in addition to all the differences that Ketanji Brown Jackson and Stephen Breyer might have, there's also the ideological difference that exists in these other transitions. And so I knew that not every transition was equal. And so I went to study it. Publisher says, that might be interesting to law professors, but we're trying to sell books. And so,
So your publisher just read my mind. I was like, that's fascinating.
and so,
Yeah.
and so maybe it's, I think it's fascinating, and maybe other law professors do. But really what I was trying to do was prove the point that this particular transition was, if not then among the most impactful. And it's, luckily the data bore that out. That's a long way of getting around to, it shouldn't be that these random moments matter so much. Why should it matter that an appointment in 2020 and an appointment in 2022 have vastly different consequences on the working of the Supreme Court? Yet that's exactly what we have. The appointment of Amy Coney Barrett is transformative for the court. The appointment of Ketanji Brown Jackson, again, symbolically hugely important, but in terms of the workings of the court, not moving the needle in a tremendous way. And so I think that screams out that something is in need of fix. The idea that people would strategically resign, and depending on who the president is, these are things that I think are beyond what the framers imagined. And at this point, it's not even the framers; it's the Congresses that have created the Supreme Court and given us the number, 9, which of course it wasn't always. And so I think that the unpredictability of it is, for me, what screams out most for reform. And so what I would want, and I'm not someone who, is going to judge whether a particular proposal is legitimate or not legitimate, but I would want something with consistency and predictability. So I'm drawn to the 18-year terms, or something along those lines as possible reforms, because I think that fixes some of, obviously things happen. You're not always going to get 18 years for everybody, but I do think that no other constitutional transition happens in a random way. We know when the congressional elections are. We know when the presidential elections are. We don't know when judicial vacancies are going to occur.
Well, I really appreciate your take on the current political milieu and the contribution to the discussion and thought process about Supreme Court reform. I think we've gone from history to present day, and I think this is a great place to end our conversation. People who want to know more should get Professor Daniel Kiel's book, The Transition: Interpreting Justice from Thurgood Marshall to Clarence Thomas, from Stanford University Press. And I'm sure you will enjoy reading it. I encourage everyone to get it. Thank you so much for your time and for this wonderful conversation, Professor Kiel. Appreciate it.
Yes, thank you so much. And thank you to the Law Review students who helped coordinate this. It's really been a joy.